Yo yo, what's good YouTube? It's your boy, Lawless, back with another one. Today, we get into reasonable articulable suspicion. Uh, this is important when it comes to stop and frisk. Stop and frisk came about from our landmark cases, Terry v. Ohio. In that case, Terry, one of and his accomplices were outside of a store, peering into it, pacing back and forth, and conferring with each other. An officer noticed this. He was observing them for roughly 10 to 12 minutes. And then he began his investigation. Yeah, I call it an investigation because stop and frisk is an investigatory tool. And a reasonable, articulable suspicion is the burden that the state needs to effectuate this tool. So the officer, I believe Officer McFadden, goes up to the gentleman. He stops them. The stop is, a seizure, like a detention. Not the same as an arrest. An arrest requires probable cause. But here, since he's only investigating, he was able to stop them for a reasonable amount of time and to conduct that investigation to alleviate his suspicion, or if he gained probable cause to effectuate an arrest, which he did effectuate an arrest here. So he stopped them, asked a couple questions. They mumbled something and turned into each other, mumbled something in which the officer physically grabbed Terry. He then went and frisked Terry. Frisk is a pat down. It consists of patting down the outer garments. This is for cops to make sure that when they're investigating, that they are safe. And sometimes they might find a drug, but usually it needs to be apparent that it is a drug. So if you have something like bulging in a drug-like manner, maybe they'll reach in your pocket and pull it out. But here, Terry had a pistol on him, so the officer patted him down, noticed the pistol. He ended up having all the guys, lift up their hands, face a wall, and, he removed that pistol. Terry ended up going to, being charged and convicted for that possession of that firearm. That's really the short gist of that case, a little synopsis of it. And I kind of want to actually move to a second case, Illinois v Wardlow. And I want to tie this back into reasonable, articulable suspicion. So, in that case with Illinois v Wardlow, Wardlow was in a high crime area. The police were going into this area to search for people who are trafficking narcotics. Wardlow, supposedly, he looked in the direction of the officers, and then, I think as they say in Chicago, he patted earth, or he fled, ran away, The officers in that case ended up catching him. They ended up patting him down. They found a pistol on him, and yeah, he ended up trying to have that emotion to suppress that, which didn't turn out in his favor once it reached the Supreme Court. But from that case, we got to see the Supreme Court say, no, being in a high crime area isn't enough for reasonable, articulable suspicion. We also got to see that evasive behavior may lead to a reasonable, articulable suspicion. That would be like his running. So basically, in this case, I just wanted to make note that sometimes not a single factor that is used to create this reasonable, articulable suspicion. Okay, and I want to keep drilling that in your head. We saw here it wasn't, being in a high crime area, and even in that case, ignoring the police, just walking away without more isn't enough for that reasonable, articulable suspicion. But when they were taking the circumstance, you might say the totality of the circumstances, but yeah, if you looked at the picture as a whole, they piece it together, and the court did find that, hey, there was reasonable, articulable suspicion to stop and frisk Wardlow. So, basically, in conclusion, what we're seeing here is reasonable, articulable suspicion can come about from piecing together I don't want to indicia. Indicia is like indicators. There we go. Different behaviors that might indicate criminal behavior is afoot. Okay, so it might not be that you were doing one thing or the other, but it could be that multiple things coming together led the police to this reasonable, articulable suspicion to make a stop and frisk. Alright, so that's the short and gist of reasonable, articulable suspicion. Hopefully this knowledge is useful to you. Hopefully you know if you're going about your day and you feel that you're being stopped, that you're being mindful of what indicia you're giving off to the officer. Hopefully you don't run, because that so far looks like it's strong evidence to effectuate a stop and frisk. So, sometimes, even in my own personal life, the officer might try to engage with me, and I can just walk away. Say, no, thank you. I don't want to conversate. I'm just gonna walk away. But anyways, if you like this video, like, comment, subscribe. Till next time, be easy, be blessed, peace.